Start. I want to welcome Kim. I want to welcome all my colleagues here today. We seem to have Marius, also one of colleagues from South Africa here tuning in from his office. And we have Unati and Lulamile. And then Kim, if you want to introduce yourself first.
Hello, my name's Kim Nair. Can you hear me well?
Yes.
I sometimes softly, so just wave your, type loudly into the chat box if you can't hear me at any time. There's a lot of echo, and I'm wondering if when we're not speaking, perhaps we could keep our mics on mute.
Yes, I'm doing that. Muting. Okay, is it better?
For me, it's much better, yes.
Okay, so I'm Benito Trolep. I'm the Afrikaans researcher here at the South African Centre for Digital Language Resources. Kim and I met in Utrecht earlier this year, and we got really interested in the topic of copyright and Indigenous knowledge and how these two systems interact. And we are hosting this webinar, not presenting, but hosting, to elicit questions and comments from people to further the discussion. Kim, can I ask you to just repeat what you said while the echo was happening? We didn't hear anything.
Oh, okay. I just introduced myself. My name is Kim Nair. I head the law library at Cornell Law School, and I recently came from the University of Victoria in Canada. So Cornell Law School is in the United States, and so I am Canadian. And most of my legal knowledge is, I used to practice law in Canada as well, and most of my legal knowledge is in the Canadian context. And at University of Victoria, there's a heavy Indigenous law development. There's the first program of its kind that offers a joint degree in common law and Indigenous law is being offered there. I think this is the second or third year of that program. So I learned a fair bit from the faculty there, and I'm beginning to work with faculty here at Cornell as well in this area. And copyright is something that I have a background in the Canadian legal context.
Okay. And then we are going to, are we, everybody muted? I think I've muted all the right people. Okay, so I'm going to share the PowerPoint presentation just for everybody to see the title and our contact details for anybody who wants to contact us. So on your screen now, you should be able to see just the title page and just a few arrangements before we start. The first thing is that we want to really use the comment section on the video interface. And seeing as we have a lot of colleagues in the room today, I would ask you to write down questions and raise your hand. And then before you ask a question, you can introduce yourself and we will take it from there. And participants are muted for now, but once you want to ask a question, just type a Q into the chat screen and Kim or myself will see it and just take note. And then seeing as we are just a few of us in the room, all from South Africa, Kim from the US, we can just ask anybody else who's viewing, who's tuning in to maybe just type what country you are viewing from into the comment section just to see how far the reach for this webinar goes. And then we will be adding the links to the specific statutes we are using into the comment section for those who want to download the statutes. Okay, more than that for now, I think we're fine. Kim, are you fine?
I am fine. I have unmuted myself.
Are you fine?
I am fine.
Okay, so we can continue. First of all, we're going through our overview. So we first have an introduction that just introducing examples of indigenous peoples from different countries. After that, we are going to define indigenous knowledge according to a very recent statute in South Africa. We are going to look at other indigenous knowledge measures worldwide. We are going to look specifically at copyright, how copyright influences or interacts with indigenous knowledge, the South African context, with specific reference to a new statute that was passed, the Protection, Promotion, Development and Management of Indigenous Knowledge Act in August of this year. Then we're going through the Canadian context with Kim, and Kim will also discuss Indigenous knowledge under Canadian law, and then we'll just mention a few things about future collaboration. So first of all, introduction. Examples of indigenous people from South Africa, for example, are the Khoisan and the Khoisan, including the Kwe, the Kurana, and the Griqua clan. So it's a group of hunter-gatherers still living in South Africa. Kim, you can maybe say something about Canada and the US?
Yes. So, of course, these lands were occupied by indigenous people before Europeans arrived. So the indigenous nations that are on the Canada and U.S. soil, or what's now Canada and the U.S., of course, overlap. So in Canada, though, officially under the law, there are 634 recognized First Nations, and that's in addition to Métis and Inuit people. So I've just listed a few of those many communities there. And in the United States, I understand there are about 566 recognized sovereign indigenous nations as well. And again, some examples are listed, and also again these overlap. So you will see Seneca people in the south of Canada, and you will see Ojibwe people and Cree people in the United States as well.
Okay, and then in this one as well. I'm muted. Kim, are you still seeing the slides?
I am not seeing the slides.
Okay, sorry. Let me reshare. We have 2 comments. Vanessa, welcome. We just said at the beginning we muted people just for sound quality. So once we have questions, we will start unmuting. If you have a question, just drop a Q into the comment section and we will attend to that. And we have Lulamile, sorry, I don't know if pronunciation is fine. Who's a PhD student studying engineering here on this campus, and he's based in Johannesburg. So sorry about that interjection, but welcome to everyone. We can just reshare the slides and continue. So the introduction was just to introduce some of the indigenous peoples worldwide, and we said New Zealand has the Maoris, which some people might know from the New Zealand rugby team always starting again with the haka. It's part of this traditions. And then more information of global indigenous peoples are published in a yearly or an annual journal on the website of the International Work Group for Indigenous Communities. I'm not sure about the exact abbreviation, but they have on this link, when you access the link, you go to this page and you get this whole journal, which gives an annual update on what did the indigenous community in that language experience that past year.
And I just will add that we're no longer seeing the slides.
Okay, reshare. So if you open the link to the journal, you open it to this page, and it's actually the PDF of this whole annual report on Indigenous communities, listed by country and continent as well as international processes. So it's very informative to anybody who wants to read. Okay, so we can switch back to the slides again. And we just gave some examples of Indigenous communities worldwide. And now we can go through one possible definition of what is Indigenous knowledge. And this definition is taken from the recent statute in South Africa, the Protection, Promotion, Development and Management of Indigenous Knowledge Act 6 of 2019. So the Act defines Indigenous knowledge as knowledge which has been developed within an Indigenous community and has been assimilated into the cultural and social identity of that community, and includes knowledge of a functional nature, knowledge of natural resources, and Indigenous cultural expressions. Indigenous cultural expressions includes verbal and action tangible expressions. So the question is whether that then qualifies, that assists in qualifying language as Indigenous knowledge. Now, Kim and I thought this would be a great slide to pause a bit for questions, possibly comments from anybody who either has comments on the definition, on adding to it, on what's already there, or wondering what is functional Indigenous knowledge, what is knowledge of natural resources, and yeah, just anything anybody wants to add to this.
I would like to know about the functional issue.
Okay, quickly stop sharing. So if we open this, we have a comment. Okay, was Vilamile saying thank you. So we have a question from the room. Prof.
Ati De Lange from Sadler. I would like to know the functional language. What is meant by functional or functional knowledge? What does it mean? Is it like farming practices, or what exactly do I understand under that description in the document?
That would be my understanding. That's how I took it to mean, to refer to practices that are well known and well established in a particular Indigenous community that can be considered part of the knowledge, the body of knowledge used. And Benito and I earlier were talking about the concept of owned and exploiting the knowledge, but established knowledge including processes like farming, production of any other kind.
May I ask a follow-up?
Yeah.
If you have two Indigenous groups who are very closely related, and this kind of functional knowledge is shared by them, with some deviation here and there, but for the biggest part of it, it's the same. How do you assign the knowledge practices to one or the other community as their knowledge?
Well, that's again when we get into the point and purpose or the value of assigning ownership is, I guess the question that I have is to what extent it matters until we get to the point of commercial exploitation. So is there, this is something that, it's worldwide. I'm certainly no expert on this subject, but I did research, it's maybe 15 years ago or so, on Indigenous knowledge and cultural knowledge in the Global South. And I guess where it becomes important is somebody who comes along, and in the case, in the article that I wrote and the things that I researched were related to patents that were intended to be created where a Western or multinational company went, for example, try to patent seeds or growth patterns or processes for basmati rice, for example, in India. then whose property is that? Who gets the right to do that? It really only it became an issue when it became a matter of competition and ownership and exploitation for commercial gain.
Thank you.
Yeah, I also want to add on this point, the statute, the South African statute, aims to deal with, because it wants to regulate the use of Indigenous knowledge, especially commercial gain, and making sure the Indigenous community benefits from any commercial application of their knowledge. So there's specific sections from the Act addressing whether a specific type of Indigenous knowledge originated from different communities. So they will be able, once the committee is set up and once people are entrusted with the knowledge, a trustee is appointed for every Indigenous community, they start engaging in, do you have similar knowledge to the one we have? Who has the right to register this? So to who do I have to apply if I want to use it in a movie? So that becomes relevant as soon as this committee can get off the ground and starts the process.
Okay. And I think that's going to be a really important question, and that's likely going to be a lot of discussion and negotiation and potentially litigation as well down the road.
Okay, anybody else? I don't see anything in the comments, so for now I think we can continue. Okay, so we can go back to our slides. So we did this definition of Indigenous knowledge. We had a question, we can continue. Indigenous knowledge measures worldwide. There's the Treaty of Waitangi in New Zealand, which was already signed in 1840. And then the ILO, or the International Labour Organization Convention on Indigenous and Tribal Peoples from 1989 was also an international measure that I know for a fact South Africa is trying to ratify. And then the United Nations Declaration on the Rights of Indigenous Peoples is also something I know South Africa is trying to ratify. Kim is going to talk later about the context in Canada about it. And then recently South Africa has the Protection, Promotion, Development and Management of Indigenous Knowledge Act 2019. So there's a lot more. We just listed some examples. So from now, it's going to be Kim talking about copyright and the Canadian context.
Yes, so copyright as a concept is Western-based. It was the law that found most common, the statutes governing copyright in most common law countries at least, and I believe as well in those jurisdictions in the world that have adopted civil law, derives from an old English statute called the Statute of Anne that was enacted in 1710. And you can see the full title, the original full title of it was for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of copies. And it really had to do with the time the printing press was available and to regulate and control the unauthorized copying and distribution of print materials without the knowledge or compensation or approval of the original authors. So next slide.
Kim?
Okay, so so there is copyright, of course, legislation that derived from and took different directions, somewhat different directions from the Statute of Anne. If you look at the WIPO or WIPO, some people say, the World Intellectual Property Organization website, you can see a list of that. And Benito, in South Africa, I guess you have an Intellectual Property Act that was amended to actually explicitly include Indigenous knowledge. Could you speak a little bit about that to explain what is meant by including Indigenous knowledge?
Yeah, so the amendment added in 2013 was just to, it was very vague. It was formulated before the bill for the current act was there. So it was broadly just saying that Indigenous knowledge is protected by copyright without saying anything else. So it was, I think, there for someone to use should it become relevant in a case, but I'm not aware that anybody actually used it before.
So I guess from my perspective, if we think of copyright as really originating from a very Western perspective and in a very specific context to control and regulate the reproduction of things and to ensure authorized versus unauthorized reproduction and, again, commercial exploitation, the question is, to what extent is that reconcilable with the protection of Indigenous knowledge? Knowing that Indigenous knowledge is not a single monolithic thing. There are many Indigenous communities around the world, as we've mentioned, many with more and less formalized and developed structures of knowledge protection. And the reason that this has come up in the context in which I work is in Canada, beginning about 2 years ago, the Federal Copyright Act, which is the act that governs copyright protection in Canada, throughout Canada, was in the process of a mandatory 5-year review. And in that context, many in the legal information community, in the information community, in the Indigenous knowledge communities were wrestling with how the act should, or if the act should be amended to include and incorporate a similar kind of recognition of Indigenous knowledge protection. And it's a struggle because I do believe personally that Western copyright is a different concept, and incorporating Indigenous knowledge protection is a very tricky thing to do. And I'll speak more about that specifically when we talk in detail about the Canadian law.
Okay. Sorry. I just want to welcome, I saw somebody else join, Tanya, welcome to you. I just want to remind everybody that if you have any questions, please type the Q into the chat screen and we can unmute you and you can ask your question either just in the chat, but if you want to talk, you are welcome as well. We just finished with copyright in general and where copyright originated from. We are going back to the South African context, and I still need to share the slides. So we can continue. Tanya, if you won't mind typing into the comment section where you're tuning in from. We just want to see how far our webinar is watched. Just need to share. Tanya is tuning in from Montreal, so I assume she knows Kim. But we can continue with the slides. Then I got this quote from the annual reports that I referenced earlier, saying African Indigenous San and Khoi peoples are not formally recognized in terms of national legislation as a customary or Indigenous community. However, this is shifting with the pending Traditional and Khoisan Leadership Bill of 2015. So this is also the act that will ultimately assist South Africa in ratifying the UN Declaration on the Rights of Indigenous Peoples. And traditional and Indigenous peoples in South Africa has been recognized more and more often, with the example as of 2019 in April, the language of the San and the Khoi people, Kukukuap, is a university subject you can study at the University of Cape Town in South Africa. And then specifically, going back to the South African context, specifically with reference to this new act, I just thought giving some broad outline of this act will help people to understand the possible impact it can have. So it was published in the Government Gazette on the 13th of August 2019, meaning that was the date that it came into, basically, it can be used now. It is recognized as a statute. So it consists of 9 chapters with 34 sections. Section 1, as always, is the definitions. Section 2 to 3 is Chapter 2, talking about the application and objectives of the Act. Chapter 3 establishes the National Indigenous Knowledge Systems Office, which would be in control of registering and facilitating any process with regards to Indigenous knowledge. Chapter 4 speaks about the protection of Indigenous knowledge, invoking Section 25 of our Constitution, which is the property section. So that is very interesting, seeing as the actual Act does not mention copyright anywhere, but it does mention Section 25 with reference to property. Then Chapter 5, about the recognition of prior learning of people adding to the knowledge of the Indigenous community. Chapter 6 sets out the full registration process of Indigenous knowledge. Chapter 7 is about the commercial utilization, so any type of movie or novel, anything people want to make money off based on Indigenous knowledge. And Chapter 8, in the enforcement of the rights of the Indigenous community with reference to their knowledge. And it should be Chapter 9, saying general provisions which will address the problem Prof. Ati highlighted of Indigenous knowledge originating in different jurisdictions, how to deal with that. So that's going to be somebody's dedicated work. Specific sections I want to highlight is Section 11, that sets out grounds for eligibility of Indigenous knowledge. So not every piece of Indigenous knowledge, according to this Act, will be protected by this Act. It has to be proved that it has been passed down from generation to generation. It was developed within the Indigenous community that wants to register the specific knowledge, and the Indigenous knowledge associated with that community is intrinsically linked with their social and cultural identity. Then Section 13 describes the right of an Indigenous community to their Indigenous knowledge and the commercial use application of Indigenous knowledge. And interesting for academics or anybody doing research is that Section 26.4 specifies that the academic or non-commercial use of Indigenous knowledge is exempt from an application procedure to NICSO to use. So that's interesting. And ultimately Section 28, which I think will have some repercussions, is a positive protection of Indigenous knowledge through someone being charged with a fine if they are caught using Indigenous knowledge for commercial purposes without having gone through the application procedure, having got the informed consent from the community. So without going through the process, the statute specifies. So I think I will repost the link to the statute into the chat section for those of us who want to see it. We've posted it earlier, but just to repost to make sure everybody can see it, I will just copy and paste. In the meantime, is there any questions?
I actually have a question about So you mentioned the reference to Section 25 of the Constitution, which deals with property, you said. Is there any explicit reference to copyright in the Constitution, or is it simply property broadly?
Yeah, according to me, it's property in the most broad sense it can be. So I think our International Intellectual Property Act would also invoke that section.
Right, but otherwise there's no explicit reference to copyright in the South African Constitution.
That I know of. Okay, any questions from inside? Okay, Kim Jane, I think we can continue with your part. We can reshare our slides. And Kim is going to give us more insight into the Canadian context. And we are starting with the first one. Kim?
Yes, so now I'm seeing the slide. So in Canada, copyright law is a creature of statute entirely. There's no other copyright, sort of common law copyright basis. As I mentioned earlier, it derives from the Statute of Anne. There is one element that is a little bit non-statutory, but is sort of recognized in the statute, and that's the Crown Prerogative, or the Royal Prerogative, which does reserve to the right of the Queen to, among a number of other prerogatives, there is a right for certain things, but it's really not really relevant when it comes to understanding copyright law as it affects most people on a day-to-day basis and their property or their works that have copyright protection governing it. In the context of Canada, we have to think of there being constitutional obligations toward Indigenous people of the Canadian Constitution, and also there are laws that are in various states of emergence or exposition in Canada, laws of the Indigenous peoples themselves. So if we just want to speak very specifically about how Canadian law intersects with Indigenous knowledge, it's important to recognize that Canada did not have a copyright statute until 1921, and of course the lands of Canada were inhabited by Indigenous peoples who created knowledge well before that statute existed, of course, and colonials did recognize and apply the existing systems of laws of the people who lived in Canada before. And that's reflected in the treaties, the various treaties that were agreed between the peoples of the first peoples of Canada and the colonials. So if we could just go to the next slide. So when the Constitution was created in Canada, and you can see the relevant dates there, it was declared to be, as constitutions would be, the supreme law of Canada. So anything that's inconsistent with the Constitution is, of course, not of any force or effect. And that's important to keep in mind because of the next two provisions of the Constitution that I'll show you on the next slide. So any law to be of value has to be consistent with the Constitution. And the Constitution in Canada does specify and protect Indigenous rights, and it affirms those treaties and other rights that I said preceded the enactment of the Copyright Act or any other statute. So when the Constitution did come about, Section 25 and 26 clearly show that there are Aboriginal treaty and other rights that already belonged to Aboriginal peoples of Canada, and that the Constitution was continuing to respect that by providing that no other law could be inconsistent with the Constitution. And then there's a very explicit recognition in Section 35, positively affirming that existing Aboriginal and treaty rights are recognized despite the Constitution of Canada. And so it goes on to define the Aboriginal peoples of Canada and also explains what is meant by treaty rights. And again, there's a very clear, notwithstanding any other section of the Constitution itself, Aboriginal and treaty rights are guaranteed equally to male and female people, but they are guaranteed essentially under the Act. And that's a really, really important principle that has governed how Aboriginal law has developed in Canada. Was formerly more often called Aboriginal law, and when I use the word Aboriginal law, I tend to talk about the Canadian law applicable to Aboriginal or Indigenous peoples and the relationship with the country of Canada. And when I use the word Indigenous laws, I'm speaking about the laws of the Indigenous communities themselves, so not necessarily Canadian law. And this is really important to remember, and it's also interesting to note that this is not simply a section in an old constitution. It has regular life breathed into it by numerous Supreme Court of Canada cases that affirm these obligations. And also, very recently, there was a change in government, and the UN declaration that Benita talked about earlier was officially adopted in Canada. That was so. At the time that was adopted, the then minister responsible for Indigenous matters did explicitly say it will help breathe new life again into Section 35 of the Constitution. So once again, the question that I have is whether we, I like very much the South African approach in this Indigenous Knowledge Act, because I think when we talk about incorporating Indigenous knowledge and recognizing it in Canadian law, I wonder whether we actually should try to reconcile Indigenous knowledge ownership and use concepts with Canadian Copyright Act perspectives. I think that there are differences that may not be reconcilable when we're speaking about what the Copyright Act explicitly protects and provides for, how a work is defined in the Copyright Act, for example, the concept of fixed intangible forms, for example, may not be consistent with Indigenous knowledge ownership. Communities. The conceptualization of who an author is or how long a endure also may differ, and I think do differ from various peoples who have some knowledge of different Indigenous communities, knowledge protection concepts that I've spoken to. So I think that the Canadian Copyright Act is a colonial approach, and to try to incorporate a protection of Indigenous knowledge within the Act and to try to apply the Act to Indigenous knowledge directly is a very colonial approach. There have been some efforts in Canadian law to create legislation, Canadian legislation, that would respect and affirm various knowledge. I've listed some of those for you. All of those were bills that reached various stages of progress. Bill C-262, which is the act that would implement the UN Declaration on the Rights of Indigenous Peoples. After that act or that declaration was formally affirmed in 2016, is the one of these that got farthest along in the process. Now, some of you may know that today is election day in Canada, and that means that prior to today, when the election was called, Parliament was dissolved, so none of these statutes, regardless how far along in the process they got, have been passed. We will see what happens after today and after the installation of a new Parliament, what will happen and how the new Parliament will choose to approach Indigenous knowledge protection in Canadian law. So again, my approach to this, the understanding, and I'm really welcome to hear somebody disagree with me and point me in a more useful direction, but my thinking on this is for those of you who are lawyers or familiar with interaction of legal jurisdictions, I think when we speak about Indigenous knowledge protection and Canadian law, we're talking about a conflict of legal system. So I think it's impossible to try to incorporate anything into a Canadian copyright statute that would explicitly have any impact on the system of protection within the Indigenous. I think at most, a Canadian copyright statute or a separate statute like the Indigenous Knowledge Act in South Africa could define a protection or a recognition or that a protection regime exists in another context. I do think that it's inappropriate to try to absorb directly into the copyright system a regime of knowledge protections for different Indigenous communities. For one thing, Indigenous communities in Canada, as I mentioned at the outset, are not monolithic. There are many Indigenous nations that quite likely have their own conceptualizations of Indigenous knowledge, as well as, going back to the very first question, different knowledge of, or different accepted cultural practice or knowledge. So I do believe that not only is it inappropriate to absorb protections directly into the Copyright Act by creating provisions to provide for Indigenous knowledge protections, I also think it's inappropriate to say, here is the Canadian Copyright Act and we're going to apply it to So right now in Canada, when I mentioned earlier that Section 35 of the Constitution is regularly addressed in Supreme Court cases, there has been a fairly recent decision of the Canadian Supreme Court that established and recognized and firmly established and continued a duty to consult. So if the Canadian government or any provincial government wants to create some sort of a dealing that would affect Indigenous lands, there is a positive duty to consult with the Indigenous peoples involved. And I recommend that that's a similar approach we could use at this point until we have a statute like the South African one with separate regimes that are set up and established. I think that's a useful approach to take in dealing with Indigenous people's knowledge or their intellectual property as opposed to land property. So that is one recommendation that I have. I'm just one individual person, and we'll see where things flow in the future. I'm just pasting in a link which might help you. It will take you to the list of current statutes that I mentioned are not passed but exist, if you wish to explore those and find out what has been drafted in the Canadian context for Indigenous, for laws affecting Indigenous peoples.
Okay. I think we can open the floor up again for any comments. That was technically our last slide. The very last one is just pointing to future work. Kim and I want to submit an abstract to a special edition of Kula, which is a journal. And then we are also part of the group. I see Vanessa is still here. So yeah, with Vanessa Balter and other people who submitted an abstract for a forum or a panel to go to DH 2020 next year in Canada. So that's where this hopefully will go even further. So except for that, any questions, comments, discussion?
Yeah, so something that I'm also interested in many ways is this talks about more the commercial aspects of Indigenous knowledge, but there's also an aspect of your traditional, when you engage communities, any type of communities, not just Indigenous communities, and collaborate on projects and in a sense gain certain, research material from a community, and how to properly acknowledge their contribution to the project. Because sadly, it's not the best international track record when communities are engaged. Many times the research is done, and once the research is done and the researcher has written the paper, there's no further dissemination or linkage to that community for the work or the knowledge that was kind of taken from that community. How would such a forum maybe link to those aspects as well? For that proposal for DH 2020, I'm just interested.
Kim, I don't know if we can maybe give Vanessa some space to speak. I can reactivate her mic. Not sure whether she deactivated it herself. Vanessa, do you want to say something about that? I don't know if we still have her, but I think what John asks is basically when you go to a community and you interact with them for purposes of your knowledge, then it's actually there's a duty on you to go tell them what you did.
Yeah, and also kind of co-create, because in many ways the knowledge that you're taking from the community and framing that into a paper or a presentation, to what extent does that community, how are they represented as part of that paper or that contribution happening at a conference? Because in many ways it's almost a very old traditional anthropological approach where you would go, you would write up what's happening in the community and then you come and report back. But the actual community doesn't have a say in what's being shared about them or about their processes, even though that's not clearly for commercial purposes, but that's almost, in a sense, for academic commercial purposes. So my interest is just, would you also reflect on those aspects in your panel next year, if it's accepted, hopefully.
I think that is such a valuable point. And when I have these slides and examples, and I say that there may be many different Indigenous legal systems, and I don't know what their rules are, but I shouldn't apply or assume Canadian copyright law can specifically govern them. That, you know, one of the reasons that I'm so reticent about saying much is that I can't speak for a community of which I'm not a member, and I should not be purporting to represent somebody else's, not only somebody else's knowledge, but also I don't understand the legal system, which may, to more or less formalized level of expression, govern the use and reproduction and resharing of that knowledge. I think this act that you've got in South Africa is going to open up lots of very interesting cans of worms as we see it applied. Another thing to Benito and I were talking about earlier is that in the United States, so I'm fairly new here and I haven't learned much yet about the legal systems, but tribal nations in the United States, tribal councils are much more formalized and have much more developed structures. I don't know to what extent they're really governed by U.S. law or how independent their legal systems are. So if somebody had knowledge from a community, an Indigenous community in the United States that is governed by a tribal council or a tribal legal system, whether there may well be a recognized protocol for dealing with that knowledge. In the earlier presentation in Utrecht that Benito referred to, where I met Vanessa and Walter and Benito, I did speak about a process in Canada that I went through when I was at the University of Victoria. We had some materials in our library collection that were evidence used in a very long court trial that actually led to one of those Supreme Court decisions affirming a duty to consult. And in that, among the bits of evidence and exhibits were objects, knowledge, statements, written expressions of, written transcriptions of verbal evidence given by community elders. And we came to understand that that was Indigenous knowledge protected by the Chilcotin people or elders of the Chilcotin community. And for us as a library to want to archive those materials or catalog them or somehow preserve them, perhaps digitize some of that, we realized that we are dealing with another people's knowledge. And the way that we handled it in the absence of any kind of a legal system or formalized process was by agreement. So seeking permissions of representatives, first finding out who the authorized representatives were. So in that context, we reached out to the Chilcotin National Council, I think is what the name was, who were the authorized representatives, who themselves would reach out to the elders who, if the individuals weren't available, then the relevant elders of the time. And that was the approach that I was able to recommend, is one-off, basically, occasion by occasion, context-specific protocols and agreements. And I think that's a really important thing to remember, is that if we are purporting to speak to another community, we have permission to do so, or that we're doing so in the way that's acceptable to the community, which again takes us back to that very first question about knowing exactly whose knowledge we're dealing with.
Okay, I see Lamile has some comments. I'm going to activate his microphone. So, Lamile, welcome. If you want to give your comments, you are very welcome. Can you hear me?
Can you hear me?
Yes, yes.
Okay, good stuff. So I'm Lamile Mzamo. I'm doing a PhD with Prof. Bosch and Helberg at Northwestern University. I'm doing it part-time. For South Africans, I think the crux of the thing starts with the definition of indigenous. And I had a brief look at the documents that you just pushed through, that just linked. And for us, South Africans, sorry, Black South Africans, the issue is a political issue. It's very much steeped in politics, because our understanding is that the majority in South Africa are actually indigenous people, and that it is the minority in South Africa that is not indigenous. I know when one looks at when one talks to the white community of South Africa, they consider the Khoi and the San to be indigenous, and the rest of the blacks not. But if you talk to black people in South Africa, they consider the Sotho, the Tswanas, then they consider themselves to be indigenous to the country. So that's the first place where some of these things actually fall. And I had to look at the documents quickly, and the sort of identity things come through. And also, I mean, for me, this is reflected in the Act that you were referring, because it defines an indigenous community in very broad terms, and it doesn't have a specification in my reading of it to a particular grouping, but it's more about the setting in a geographical area, and that's one aspect of it. If I read other documents, I see the issue of people that were there pre-colonial. So so I just want to bring that aspect to it, to say normally we look at indigenous people as a community of few people who need this protection. But in South Africa, it's actually different. In South Africa, you've got indigenous people who actually make a vast majority of the population. Thank you.
Thank you, Lamile. I have to say, I also posted the link to a bill that's waiting to be signed by the President, which will also, I would say, add to the complexity of what is a indigenous community. Like you said in the Act, we talked about it's very broadly defined, which I agree with, and which I think is very important, because I don't think we are up to, not clued up about of indigenous communities in the country. And then the traditional lead bill that's going to be passed hopefully very soon defines a traditional community. So it's going to be interesting to see how a traditional community is either the same or a different thing than an indigenous community, and why it was necessary to make separate acts.
Yes, I agree with Gillian, and I've not read the traditional and Khoisan. I've just Bill, and I've just listened to people that spoke about it and people that actually were specifying why this is needed. And my understanding of it is needed because of the lack of recognition.
Yes.
And it's meant to do that. And hopefully when it does that, also then the Khoi sign languages also become recognized. But that still leaves a pretty gray area where the definition needs to be pinned down of who indigenous people are. That's one thing. In fact, also I wanted to add to say that, and I think Tanya did talk about this, the meaning of copyright to indigenous people, the idea in actual fact of copyright, and the idea of land ownership or individual land ownership. Those issues are alien to indigenous people, particularly because they consider themselves to be custodians, passing custodians of land and not owners. And I wonder how valuable, for example, I come from the Eastern Cape, of East Cape of South Africa, and how most of the land there is in the custodianship of traditional leaders and chiefs and kings. And even they know that they don't own the land. Even they are aware that they don't own the land, that the land actually belongs to people. So they are custodians and administer it on behalf of people. And you see then what happened in '94 around the issue of KwaZulu-Natal and the Ingonyama Trust, and how that took what is considered to be an indigenous and a shared resource and gave it into a custodian one person. So these are political issues. So I wanted to say, to bring that aspect to say, this copyright laws and ownership of resources is a really alien thing that indigenous people don't understand. And I wonder if these things need to be forced down their throats, or if they need to be given the leeway to actually manage and administer the resources in the way that the knowledge that they have and the heritage that they have has been guiding them. Thank you.
I don't know if you want to comment.
Well, I think that is the crux of it, isn't it? And I can't speak to the conceptualizations of indigenous in South Africa, but what is told by.
Sorry, Kim. Just wait a second.
Okay.
I'm just quickly going to deactivate your mic just for the sound quality, so Kim can answer, and then I'll activate again if you want to comment again. Okay, sorry, Kim.
No, I was just saying that that conceptualization is very similar from what I understand from people who are members of particular indigenous communities in Canada have told me, that concept of ownership is not, it is alien to some indigenous communities in Canada as well, and even when we think about the treaties and the way early treaties were negotiated, as I had mentioned, between European colonials and the indigenous peoples of the regions, that the conceptualization of what was being done in the land treaty or other treaty was also different. That no one was meaning to pass ownership of a land, because that was not really a concept. As you said, custodianship of the land was more of the concept that was understood. At least this is what I understand from what others have said in Canada. And yeah, it is a little bit of a challenge, and you know, I do like the fact that there is a statute that exists called the Indigenous Knowledge Act, or which can be shortened to the Indigenous Knowledge Act, that does not actually use the word copyright in it anywhere, even though there are provisions that deal with the ability to protect cultural property or indigenous knowledge. And the reference to property might even only be indirect as well. I can't remember whether I searched for the term property, but I did search for the term copyright, and it appears nowhere in that statute. But yeah, that is really the crux of it. I think we're at the point internationally where we are applying these Western notions of ownership, of copyright, and permissions to the knowledge systems of anyone, you know, other communities around the world. And I mentioned earlier at the start that years ago I had done some research on cultural property in the global south, and you know, very similar concepts of no one really owns the recipe to cultivating basmati rice. You plant it and you feed the community until it became popular to consume in other parts of the world, and some multinational corporations decided they wanted to patent the seeds. So yeah, it's a problem applying the concept of ownership and commercial exploitation to knowledge that was not necessarily meant by a particular community to actually have that purpose or value.
I also made a note while we spoke that, seeing property as something you individually own is something inherently Western in my mind, that you have to profit from your knowledge. It's not there to help the community, it's there to help you. And I think, that's something, in the conflict of different legal systems that gets...
yes, and it's why I wrote that earlier slide that the notions of knowledge may be different. And from people that I've spoken to, there is no term of protection, and thereafter exploitation becomes valued for certain types of knowledge. The knowledge of an elder belongs to the community, in the sense that to the extent that it belongs to anyone. That's a really good point.
Thank you, Vanessa. Vanessa is just greeting. She's got to run. But I'll reactivate Lula Mile if he wants to say something else. I just want to finish by saying, or not finish, but finish this part by saying that I think what the Indigenous Knowledge Act can provide in terms of protecting the knowledge is important. Registering oral traditions, I can't even imagine how that will happen, but I think the idea is positive. Lula Mile? I did.
Yes, can you hear me?
Yes, yes.
Awesome. Yeah, I'm not, but I'm doubtful. I think the question that you asked just now about the complexity of registering the vast amount of cultural things that could be thought of as indigenous knowledge is overwhelming. Another approach, I don't know, I've not read the actual act, and I am just hoping that maybe it is event-based, where the actual person who wants the copyright, because remember, one for indigenous person to want to own indigenous knowledge is almost like trespassing. And one should then look at, well, the person who's trespassing has to prove that they are not trespassing. So I hope that it approaches that way, because to expect that first things must be registered for them to be protected, then I think that would be a problem, because there's just too much stuff to actually register. So I don't know, I've not read the document, but that's what I wanted to bring in to say. This was an approach to cultural artifacts and cultural things, and cultural things, and in that one uses the word cultural things to mean even the recipes that one uses to make medicine, African medicine, as cultural things. It becomes very, very difficult to apply that. But I don't know how one. I guess also what I wanted to bring in was we do know that commercializing things brings prosperity and progress, and that's the thing that then indigenous communities will have to think about how do they ensure that they can actually benefit and prosper from the things that they know without losing their values, because this thing of not owning is the value that the community has. So they've got to find a way to balance that so that there's prosperity, but at the same time they don't lose themselves. Thank you. I think I'm done.
Thank you, Lula. It was very, you really gave insightful comments, and what I think is important, what you said is the community has to benefit from the commercial use of their knowledge. And the Act makes provision for that. But I think, like you said, it's important for them not to lose themselves in, what can you register? Is there allowed information? Is there allowed knowledge in terms of, can I have it recorded? Because, I don't know. So I think it's going to be an interesting time once someone starts implementing all the provisions in the Act.
I completely agree with that. I think from my perspective, what's useful and valuable about this Act is that it does recognize that other communities have their own conceptualizations of knowledge and ownership or not, and also use, and allows those communities to establish the rules.
And Dion wanted to say something.
Yes, hello, Dion, English researcher here at SADILA. First off, I would like to say, Kim, and to all the other participants, thank you for the conversation this afternoon, South African time. I think this is more of an observation, my big takeaway from the conversation than it's anything else. And it's something that Lula Mile has also touched on. The idea that Western notions and indigenous notions of ownership differ. And I think we should tread very lightly, and wherever we are in a position to caution legislators, also advise them to tread very lightly so that we don't try and protect whatever conceptualization of ownership or quasi-ownership or whatever you want to call it that community has, and that in itself that notion might be destroyed in our attempt to protect some other cultural artifact. And something else is, and I think this is perhaps the big heading that you can put over that, and this is something you mentioned yourself, Kim, that some of the approaches are very colonial. Well-intentioned, but they remain very colonial, and I think that is something that's going to be a very long, very hard discussion, but I think it's good that we are having them.
So
I think Tanya is commenting. Kim, if you want to respond.
Yes, I just wanted to add that I think, if I understand correctly, there was a good deal of consultation with communities.
For this Act specifically.
Yes, and that's essential, of course. Otherwise, why try, as you said, the intention may be good, but if it's just reinforcing a colonial approach to protecting someone else's, it's not only colonial, it's patronizing also.
Yes.
So yes, Tanya had an interesting point.
I can activate her mic if she wants to speak. Oh, I see she deactivated her mic herself, so we can either read what she said, or if she wants to activate her microphone, she's more than welcome. Tanya? Okay, maybe I can read what you typed. She just says that it reminds her of the false face masks by the Iroquois. And she said there's a whole ritual with how they are created that's secret to the community and only passed from one person to another. The elderly are again sharing that knowledge openly, whereas the younger generation disagree. So I think that, that's going to be an interesting, also dynamic, once it comes to who has the final say in saying something can be recorded, to preserve it, to have it, filed somewhere for future use. So I think the point that Tanya is making is very important for Indigenous communities in general. I know of a recent movie that came out last year about initiation practices of one of our Indigenous communities. And there was public outcry because it wasn't supposed, first of all, it was a film, so it was commercial. And second of all, it was traditional practices that should not leave the confines of the community. So I think Tanya, it's also a very important point she makes about that knowledge staying in the community to benefit the community.
If I can interject here quickly, because I find this point between the younger generation and the older generation differing, I find that very interesting, and I think obviously that's something the community needs to sort out themselves. It's not something you can come and fix externally. But something I was thinking about throughout this whole conversation is an article on the ethics of research by Penelope Eckert, where she also says, how do you find out? You mentioned earlier some tribal council, or I can't remember the precise name you used. It's easy when there are those hierarchies and we can consult them. But if there is more than, let's say it's a whole group of elders and half of them agree and half of them don't, do you say, well, half of them said it's fine, so I'm going with that half? It becomes a very interesting conversation to have.
It does, and I think it becomes a question that I would need to defer. So if the process I'm going through is the consultation and protocol development or agreement development that I suggested might be the right one to use in the absence of anything specific helping me out, I would have to say it's up to, in that case, I'm maybe not pronouncing it correctly, but Chilcotin, to tell me who is authorized, who am I authorized to speak to, or who is authorized to extend an agreement on behalf of the community. And it may be that it's particular elders at the time, maybe there's a change, and that's something that I need to allow that community to sort out. And really, I think the only thing I could do is deal with whoever's authorized at the time. But yes, just like in Canadian law, we call it a living tree. The law develops and changes over time. We can't expect Indigenous communities to be static in their conceptualization of what laws would be for an individual nation either. So that there may be a change in an evolution, as Tanya's example is pointing out. There seems to be a change among the younger generation, or at least a change that's being sought by members of the younger generation in a different approach.
And I just want to read the rest of Tanya's comments. That she said the elderly are against sharing that knowledge openly because by continuing to keep it secret, the general public lack the knowledge. And she also says the McCord Museum was forced to stop selling souvenirs of the false face masks. So that's also interesting. And Lulamile wants to say, I think the comment I made about the film, so it should be good to have is, Lulamile, you deactivate.
Awesome, thanks. Yeah, this particular one, I guess it's a good case to talk about, the one about initiation. But I guess there's also other ones. I'll give you an example. There's a king in the Cape of South Africa, King Sandile. King Sandile's mother passes away, and she's the king's mother. So I then attend the funeral. If the funeral proceeds according to Western culture for a large extent, and then it shifts, so Western Christian culture, then it shifts when it's time to go to the gravesite, completely shifts, becomes deep in tradition, and only certain people are allowed to go to the gravesite, and it shifts, and people of particular clan and all of that, and then it continues up the mountains, and it takes a couple of hours and they come back. And that also talks to the same thing that I think Tanya was saying about the secrecy of these matters, and also the same thing around the secrecy of initiation. But I think it's important to note that in all Indigenous communities, there's leadership. And so the most important thing, the first thing, has got to be the recognition of that leadership. Failing that, one is creating a situation where one wants to do whatever. So that's the first thing. Whoever brings in development first has got to recognize that there is no community that is not led. That's the first thing. So all communities are led. Another example that I have is I was in India, in Bangalore, on a Navratri session. During that 9 days, there were areas during this festival that I was not allowed to go to because of my rank, because of whatever. And this is steeped in the tradition of how this thing works. And there are certain rituals that I can't do. So it's important first to note that there is a leadership that is custodian of this thing. And that leadership must be recognized. And that's really the only thing that the only way that things can then move smoothly. And that leadership, and also one cannot, I guess, do a quick change, force a quick change in elder people because they're old for a start, and they're steeped in their traditions and cultures. So you don't force a quick change, and you have to allow communities to move the way they can to get to where they can do things. I think that's the other thing that needs to be recognized in this, because you're going to find a difference in new generation and old generation, purely because of exposure and also because of value of what people value or what the different groupings value. And I think the important thing is the recognition that actually the young people are not the leaders. The leadership is there, and the intention is for that leadership to take control internally. And that's, I guess that's where I am. That leadership must be recognized and respected. Thank you.
Oh, thank you. Yeah, I think that was a great comment or just contribution by Amelia. And if nobody else, I see Unati is also one of our participants. Unati, if you can just type into the comment section where you're from or from where you're listening, because we have people from Montreal, Kim is from New York, we are from Potchefstroom here, Lunamile is also somewhere between Johannesburg and Potchefstroom, so it's nice to see some broader representation. But more than that, this webinar has been recorded, so we are going to add it on YouTube for dissemination, so you can later get the link on Savilar's YouTube page. And more than that, if you have any questions, I can put our contact details on the screen again. Unati is a silent participant from Johannesburg, so we have Joburg, and that's good to know. But yeah, feel free to contact us with any comments. As we said, we are continuing to work on this subject, and we are enjoying learning more and having you contribute through these type of webinars or other forms we will probably go into in the future with our abstract and with the forum and the panel. Any ideas are always welcome. Kim, I don't know if you have any closing remarks.
Actually, I just wanted to add one more thing, again going back to the Chilcotin trial example, just to touch on what Tanya and Lulamine had talked about. So it was the Chilcotin national government that we dealt with, and they, as Lulamine had said, there is a specific process or leader that we had to recognize, and so that's who we dealt with. And they spoke about the perspectives of the elders. But what was interesting about that example is when we tried to trace back the time of the original donation and the time that the trial occurred, which was many years. It was one of those processes that took many, many years. When the materials came into the possession of the university, the leaders at the time were quite comfortable in having it shared. They wanted the knowledge out there. And it was only later that the concepts of, well, wait a minute, do we need to reserve the rights to protect this, or do we need to think about this a little more, that came to rise. And that's when that's when we started to be more concerned about the proper protocols and protection involved in sharing the knowledge, because of course it was a trial, it was a mandated process. The people who testified on behalf of the nation, the elders who testified, were required to, by Canadian law, testify. And so the knowledge was shared by mandate of the trial. And sort of here's some information that you might all be interested in, world. So so that's when, you know, things began to be reconsidered a little bit. So I just wanted to again emphasize that yes, there's a defined leader that needed to be addressed, and yes, concepts of the extent of knowledge sharing can change, but not necessarily, you know, assuming a conservative older standpoint and a more liberal sharing younger standpoint. It could go in the other direction as well, depending on where a community is in terms of their conceptualization of knowledge and knowledge protection.
Okay. All in all, I'll say this was a huge success, and I want to thank everybody for tuning in. I want to thank Kim for all her hard work and all the helpful questions, contributions from everybody. I hope everybody learned something today. We enjoy the topic. We enjoy speaking about it to interested people. So yeah, Kim.
I learned a lot myself. Thank you very much for coming. Thank you, Tanya. It was early in the morning here in Eastern Time for joining us. And as Benito has said, we are hoping to produce a contribution to a special issue of a journal called Kula, which is focused on Indigenous knowledge. The special issue is, and interested in collaborating with Vanessa and others on a program at DH 2020 in Ottawa.
If that's all I want to thank you, and for those who are starting their workday or just getting up, and for those of us who are finishing, thanks to everyone, and enjoy the rest of your day.
Thank you. Bye-bye.
Bye. Stop.